The next case is Muchnick v. Goihman. The opinion may be found at 43 Florida Law Weekly D 986B. The opinion was issued by Florida's 3rd District Court of Appeal on May 2nd, 2018. In this case, when the plaintiff's apartment developed mold, an agent for the landlord promised to fix the problem and he managed the repairs. However, when the plaintiff's children became ill, he terminated the lease and sued both the landlord and the agent. The landlord soon settled, and a judgment was entered with respect to the landlord. Subsequently, the trial court entered summary judgment in favor of the agent. There were 3 questions on appeal. The first question on appeal was whether the trial court had erred in finding that the agent may not be held personally liable because the agent was acting within the scope of his employment. The appellate court, the 3rd DCA, said yes, that was error, because even if the agent had been acting within the scope of his employment, the agent may be held personally liable to the extent that the agent had personally participated in the tort. The second question on appeal was whether the trial court had erred in finding that the agent could not be held personally liable because the agent was not the landlord and did not have a duty of care to the plaintiff, the tenant. The 3rd DCA again said yes, that was error, because under the undertaker's doctrine, the agent could be held personally liable because the agent had undertaken to repair the problems with the apartment. The third question on appeal was whether the trial court had erred in finding that, or in concluding that, the case against the agent was moot because the case had been settled with respect to the landlord. Again, the 3rd District Court of Appeal said that that was error because the settlement with the landlord did not indicate that it was in full satisfaction of the tenant's damages. And to the extent that the tenant's damages exceeded the amount that was settled, the settlement amount with respect to the landlord, the agent may be held liable. Accordingly, the 3rd DCA reversed the summary judgment and remanded the case for further proceedings.